Before we declare the judgment, must welcome, we have two sets of international delegations. We have the lawyers from Cambodia, from the Royal Kingdom of Cambodia. Welcome to our court. We're very glad that you're all visiting here. And we have judges from Peru here, of the Superior Court. Thank you very much for coming here and joining us. I hope you enjoy the sitting during the day.
Lord, we also welcome them, Lord, amongst us.
On behalf of the bar members, I welcome them as well.
So let me just briefly. There are as many as 6 opinions in the case. I have authored an opinion for Justice Manoj Mishra and myself. Justice Bhushan R. Gavai and Justice Pankaj Mittal have authored separate concurring opinions. Justice Gavai and I have agreed with each other's conclusions. Justice Vikramnath and Justice Satish Chandra Sharma all have agreed with the opinions of Justice Gavai and myself. Justice Bela Trivedi has dissented. The majority of us have overruled the judgment in E.V. Chinnaiya. We have held that subclassification of the scheduled caste for the purposes of reservation is permissible. Let's read out a brief extract. In State of Punjab versus Davinder Singh, a constitution bench held that the judgment in Chinnaiya requires to be revisited by a larger bench of 7 judges because it failed to consider significant aspects bearing on the issue of subclassification of the scheduled castes. Deciding the correctness of Chinnaiya, the following issues fall for our consideration. A. Whether subclassification of a reserved class is permissible under Articles 14, 15, and 16. B. Whether the scheduled castes constitute a homogeneous or a heterogeneous grouping. C. Whether Article 341 creates a homogeneous class through the operation of the deeming fiction. And D. Whether there are any limits on the scope of subclassification. The Constitution's 77th Amendment Act 1995 included Article 16(4)(a), enabling the state to provide reservations for the scheduled castes and scheduled tribes in promotion. The Constitution 82nd Amendment Act 2000 added the proviso to Article 335 stipulating that lowering the standards of evaluation will not be inconsistent with the maintenance of efficiency. The amendments recognize the difficulties and struggles faced by members of the scheduled castes and the scheduled tribes during promotion. In a formal sense, the criteria of selection for promotions a priori excludes the members of the scheduled castes and scheduled tribes because the criteria which are considered to be appropriate are not accessible to them. In a more informal but substantive manner, the members of the scheduled castes and the scheduled tribes are often unable to climb up the ladder because of the stigma of incompetence held against candidates who are selected through reservation. The stereotype operates against them because they are externalized as affirmative action beneficiaries or quota candidates. The amendments recognize the discrimination through the operation of both human conduct and recruitment processes. They are an emphatic repudiation of the binary of reservation and merit. Article 14 of the Constitution permits subclassification of a class which is not similarly situated for the purpose of the law. The court, while testing the validity of subclassification, must determine if the class is homogeneous and an integrated class for fulfilling the object of the subclassification. A class which is not integrated for the purpose can be further classified upon the fulfillment of the 2-pronged intelligible differentia standard. In Indra Sawhney, this court did not limit the application of subclassification only to the other backward class. This court upheld the application of the principle to beneficiary classes under Articles 15(4) and 16(4). Article 341(1) does not create a deeming fiction. The phrase deemed is used in the provision to mean that the castes or groups notified by the President shall be regarded as a scheduled caste. The inclusion of the word deemed in Articles 341(2) and 342(2) does not create a legal fiction, since it does not provide any artificial construction. To that extent, the observations of the 3-judge bench of this court in Puneet Rai versus Dinesh Chaudhary that Article 341(2) creates a deeming fiction are erroneous. Even if it is accepted that the deeming fiction is used for the creation of a constitutional identity, the fiction can neither be extended to other purposes, nor can it create legal consequences that do not logically flow from the fiction. The purpose of the deeming fiction, even if one is assumed, is identification of castes which are the scheduled castes. The inclusion of certain castes within the scheduled caste category is only to demarcate them from other castes which are not included in the category. The inclusion does not automatically lead to the formation of a uniform and internally homogeneous class which cannot be further classified. Subclassification within the scheduled castes does not violate Article 341(2), because the castes are not per se included in or excluded from the list. Subclassification would violate the provision only when either preference or exclusive benefit is provided to certain castes or groups of the scheduled castes over all the seats reserved for the class. Historical and empirical evidence indicates that the scheduled castes are not a homogeneous class. A. The depressed classes were identified based on the notion of untouchability and not in the literal sense of the term. The effect of adopting the notional and not the literal test is that the social condition of all the castes included within the depressed classes is not uniform. And B. The heterogeneity within the class is also evident from the Constitution Scheduled Castes Order 1950, where certain castes are notified as a scheduled caste in specific localities. For example, in the state of Madhya Pradesh, of the 25 castes, only 9 are scheduled castes throughout the state. The criteria used to identify the scheduled caste itself indicates that the endeavor was not to include all castes that suffered from identical forms of untouchability. The state, in exercise of the power under Articles 15.4 and 16.4, can further classify the scheduled castes. The first prong of the test for subclassification is whether the scheduled castes form a homogeneous group, integrated class, for all purposes. We have held above that even if Article 341 creates a deeming fiction, the provision does not create an integrated class that cannot be further subclassified. The provision only puts certain castes or groups or parts of them into a group called the scheduled castes. The castes or groups within the scheduled castes form an integrated class for the limited purpose of constitutional identification. They do not form an integrated class for any other purpose. We have also established through historical and empirical evidence that the scheduled castes notified by the President under Article 341 are a heterogeneous class where groups within the class suffer from varying degrees of social backwardness. Thus, the first test is satisfied. The state, in exercise of its power under Articles 15 and 16, is free to identify the different degrees of social backwardness and provide special provisions such as reservation to achieve the specific degree of harm identified. If the scheduled castes are not similarly situated for the purpose of the law or the specific harm identified, there is nothing in Articles 15, 16, and 341 which prevents the state from applying the principle of subclassification of the class. Thus, the scheduled caste can be further classified if A. There is a rational principle for differentiation, and B. If the rational principle has a nexus with the purpose of subclassification. The scope of subclassification of the scheduled castes is summarized below. A. Since the purpose of Articles 15.4 and 16.4 is to ensure equality of opportunity of the socially backward classes, the criterion for subclassification within a class, be it the other backward classes or the scheduled castes or tribes, must be an indicator of social backwardness, and B. Since the state can use any yardstick to determine inter se backwardness, it is not necessary that the criteria for subclassification and the criteria used to distinguish the class from the other classes must be the same. That is, that the criteria for recognizing the scheduled caste as a backward class is untouchability. It is not necessary that the group can be subclassified only if there is inter se backwardness due to the same identity, that is untouchability. The course of action adopted by the state is subject to judicial review when faced with a constitutional challenge. Where the action is challenged, the state will have to justify the basis of its action. The basis of the subclassification and the model which has been followed will have to be justified on the basis of empirical data gathered by the state. In other words, while the state may embark on an exercise of subclassification, it must do so on the basis of quantifiable and demonstrable data bearing on the levels of backwardness and representation in the services of the state. It cannot, in other words, merely act on its whims or as a matter of political expediency. The decision of the state is amenable to judicial review. A. The objective of any form of affirmative action, including subclassification, is to provide substantive equality of opportunity for the backward classes. The state can subclassify inter alia based on inadequate representation of certain castes. B. The state must collect data on the inadequacy of representation in the services of the state. The inference in Nagaraj that cadre must be taken as a unit to determine inadequacy of representation, inadequacy of reservation, based on the observations in R.K. Savarwal, in our respectful opinion, is misplaced. The cadre as a unit was considered only for the purpose of preparation of rosters to draw a balance between the reserved and open seats. This court did not hold that the cadre must be used as a unit for the purpose of determining the adequacy of representation. And C. Conventionally, the state has assessed if the class is adequately represented by comparing the representation of the class in the services to the total population of the state. However, adequacy of representation, when determined purely from a numerical perspective, without accounting for factors such as representation vis-a-vis posts, would dilute the purpose of the provision. The objective of Article 16(4) is to ensure effective representation of the class in the services of the state across posts and grades. Classes which are socially backward occupy the lowest of the social strata, primarily because of the traditional occupation accorded to the class by social rules. For example, certain Dalit castes are regarded as scavenger castes. Even with the provision for reservation, it is very difficult for the backward classes to share the traditional occupation that is ascribed to them by society and optimize the opportunities even at the lowest levels. The struggles that the class faces do not disappear with the representation in the lower grades. The endeavor is to ensure true and effective representation of the socially backward classes across posts. Thus, for the above reasons, the holding in Chinaya that subclassification of the scheduled castes is impermissible is overruled. The scope and limits of subclassification of the scheduled castes shall be as prescribed in the judgment. The registry is directed to obtain administrative instructions from the Chief Justice for placing the matters before an appropriate.
Obliged to not.
Just, what's okay.
Go through the erudite and scholarly judgment authored by the Honorable the Chief Justice of India. In complete agreement with the conclusions arrived at by the Honorable CJI. However, in addition to the conclusions arrived at by the learned Chief Justice, I also arrived at some additional conclusions to which the learned Chief Justice has also agreed. Therefore, I thought necessary to give my separate opinion. In the beginning, I referred to the celebrated speech of Dr. Ambedkar on 25th of November 1949, the Constituent Assembly, wherein he has said that unless we have a social democracy, political democracy would be of no use. And then he had warned us about the contradictions in economic and social plane in the country. I referred to the history as to how the term scheduled caste has come in the Constitution from the original depressed classes. I referred to the census report of 1891, the Indian Statutory Commission report of 1930, census report of 1931, the Government of India Act of 1935, and the Government of India Scheduled Caste Order of 1936. I also referred to the repairs in the Constituent Assembly with regard to Article 300A and 300B, which are now Article 341 and 340. I referred to and analyzed the following judgments of the Supreme Court. This court in the case of M.R. Balaji versus State of Mysore, State of Kerala versus N.M. Thomas, Akhil Bharatiya Shishit Karmachari Sangh versus Union of India, K.C. Vasant Kumar versus State of Karnataka, Indra Sawhney versus Union of India, M. Nagaraj versus Union of India, Colonel Singh versus Narayan Gupta. I have considered the interplay between Article 14, 15, 16, 46, 35, 338, 341, 342, and 366. Before reading the conclusions, I would read some of the observations that I made in my judgment. I have observed that the basic error that appears to have been committed in EVA Chinaya is that it proceeds on the understanding that Article 341 has to do with the reservation of the seats. As already discussed here in above, Article 341 and 342 are only with regard to identification of the scheduled caste and scheduled tribes. Article 341 and 342, read with clause 24 and 25 of Article 366 of the Constitution, provide that those castes included in the presidential list shall be deemed to be scheduled caste and scheduled tribes for the purpose of the Constitution. However, at the cost of repetition, I reiterated that Article 341 and 342 do not deal with reservation. The provisions of affirmative action, including reservation, the matter of public employment, are contained in Article 16 of the Constitution of India. I observed that, as already discussed here above, this court in Indra Sawhney has held that further classification of backward classes into backward and more backward classes is permissible in law. By that corollary, if a state finds that any of the caste, races, tribes, or parts of or groups within the caste, races, or tribes are not adequately represented, should the state be denied its right to make a special provision for them? I find that, as has been observed by this court in various judgments, it is the duty of the state to give preferential treatment to the backward class of citizens who are not adequately represented. If the state, while discharging that duty, finds that certain categories within the scheduled caste and scheduled tribes are not adequately represented, and only the people belonging few of the categories are enjoying the entire benefit reserved for scheduled caste and scheduled tribes, can the state be denied its right to give more preferential treatment for such categories? In my view, the answer would be in the negative, since the same would not amount to tinkering with the presentation list. No doubt that if the state decides to provide 100% of the reservation for scheduled caste to one or more categories enlisted in the presidential list in that state to the exclusion of some categories, it may amount to tinkering with that list, because in effect, it would amount to denial of benefit of reservation to those scheduled caste categories which have been excluded. In my view, that would in effect amount to deletion of the said categories from the presidential list notified under Article 341 of the Constitution, which power is exclusively reserved with the Parliament. In my opinion, such exercise would not be permissible. Ground realities cannot be denied. Even amongst the scheduled castes, there are some categories who have received more inhuman treatment for centuries and generations as compared to other categories. The hardships and the backwardness which these categories have suffered historically would differ from category to category. In my view, therefore, merely because they are part of a single or a combined presidential list, it cannot be said that they form a part of a homogeneous group. I therefore have no hesitation in holding that E.V. Chennaiah has been wrongly decided. The concept of subclassification was sought to be attacked on the ground that this would lead to giving reservation for political reasons. It was argued that a political party power to gain political advantage may provide special treatment to a particular class, the scheduled caste. I see no merit in the argument. In a case like the present one, if a classification is made, it will have to be established that the group carved out from the larger group is more disadvantageous and not adequately represented. The result of classification would be to provide more preferential treatment to this more disadvantageous and less represented group. The ultimate object would be to achieve real equality amongst all the subgroups, the larger group. In any case, as has been held by judicial pronouncements, when the state does such an exercise, it will have to be supported by an empirical data. Unless the state or the commission comes to a finding that the group carved out needs special treatment, is more disadvantageous and not adequately represented as compared to the other categories in the group, such a subclassification would not stand the scrutiny of the law. I therefore find that the fear that is posed is not substantiated. I find that the attitude of the categories in the presidential list opposing such a subclassification is that of a person in the general compartment of the train. Firstly, the persons outside the compartment struggle to get into the general compartment. However, once they get inside it, they make every attempt possible to prevent the persons outside such a compartment from entering it. In fact, what the people belonging to the categories who are availing large chunk of reservations and denying a special treatment to the less privileged amongst them are doing is what the people from the higher caste have done to those people for centuries, as a result of which backward classes were kept away from the mainstream of the society for ages, for no fault of theirs. Only on account of the principle of social and economic justice, as enshrined under the Constitution, they have availed themselves of the benefits of special treatment. However, when the state endeavors to ensure that the said benefit percolates to more underprivileged and less adequately represented, the sections from the scheduled caste who oppose them stand in the shoes of those who oppress them. In M. Nagaraj, the court also applied the principles of quantifiable data and criminal layer even in case of scheduled caste and scheduled tribes. The correctness of the same was considered by Colonel Singh. So General Singh held that insofar as applicability of quantifiable data on the backwardness insofar as scheduled caste and scheduled tribes is concerned, M. Nagaraj was not correct. However, insofar as the applicability of creamy layer principle even to scheduled caste and scheduled tribe is concerned, it upheld the view taken in M. Raj. In doing so, General Singh is basically relying on the judgment of 7-judge bench of this court in N.M. Thomas. The view taken in General Singh has also been approved in Davinder Singh. The correctness of the view taken in General Singh and Davinder Singh is not questioned. However, in the present reference, we are dealing with the question about equality amongst the group of unequals. I find it appropriate to consider the said issue also. Putting the children of the parents from the scheduled caste and scheduled tribe who on account of benefit of reservation have reached a high position and cease to be socially, economically and educationally backward, and the children of parents doing manual work in the villages in the same category would defeat the constitutional mandate. However, I may observe that taking into consideration that the Constitution itself recognizes the scheduled caste and scheduled tribe to be the most backward sections of the society, the parameters for exclusion from affirmative action of the persons belonging to this category may not be the same as applicable to other classes. If a person from such a category, by buying the benefit of reservation, achieved a position of a fume or maybe a sweeper, would continue to belong to a socially, economically, and educationally backward class. At the same time, people from this category, who after having availed the benefits of reservation, have reached the high echelons in life, cannot be considered to be socially, economic, and educationally backward, plus to continue availing the benefit of affirmative action. They have already reached a stage where on their own accord walk out of the special provisions and give way to the deserving and needy. I may gainfully refer to the observations of Dr. B.R. Ambedkar. I quote, history shows that where ethics and economics come in conflict, victory is always with economics. Vested interests have never been known to have willingly divested themselves unless there was sufficient force to compel them, unquote. I am therefore of the view that the state must evolve a policy for identifying the creamy layer given to the scheduled caste and scheduled tribes so as to exclude them from the benefit of affirmative action. In my view, only this and this alone can achieve the real equality as enshrined under the Constitution. I read my conclusions. I therefore hold that E.V. Chinnaya, which held that sub-classification among the scheduled castes for the purpose of giving more beneficial treatment to a group in the larger group of the scheduled caste is not permissible, does not lay down a good law. That sub-classification among the scheduled castes for giving more beneficial treatment is permissible in law. That for doing so, the state will have to justify that the group for which more beneficial treatment is provided is inadequately represented as compared to the other castes in the state list. That while doing so, the state will have to justify the same on the basis of empirical data that the subclass in whose favor such more beneficial treatment is provided is not adequately represented. But however, while providing for subclassification, the state would not be entitled to reserve 100% seats available for scheduled castes in favor of a subclass to the exclusion of other castes in the list. That such a subclassification would be permissible only if there is a reservation for a subclass as well as a larger class. That the finding of M. Nagaraj, General Singh and Davinder Singh, the effect that creamy layer principle is also applicable to scheduled castes and scheduled tribes lays down the correct of law. That the criteria for exclusion of the creamy layer from the scheduled caste and scheduled tribe for the purpose of affirmative action be different from the criteria as applicable to the other backward classes. Before I part with that, my judgment, I place on record my deep appreciation for the valuable assistance rendered by the learned counsels.
Obliged to.
My opinion is the most lengthy, as it incorporates the exhaustive and well-considered opinions of Honorable the Chief Justice and Brother Justice Roy. However, I have made the conclusions and the opinion shortest. May I read it? I am generally in agreement with the reasons and conclusions arrived at in the opinions of Honorable the Chief Justice and Brother Justice Gawai. In particular, that the holding in E.V. Chennaiya that subclassification within scheduled caste was impermissible, does not lay down good law and stands overruled. Further, any exercise involving subclassification by the state must be supported by empirical data. I am also in agreement with the opinion of Brother Justice Gawai that creamy layer principle is also applicable to scheduled castes and scheduled tribes, and that the criteria for exclusion of creamy layer for the purpose of affirmative action would be different from the criteria as applicable to the other backward classes.
Obliged, Your Lordship. Justice Sharma. His views.
So unanimity and consensus in the opinions expressed by the larger benches on the constitutional matters are desirable for the sake of certainty and strength of the law laid down. I, for one, believe that the dissent for well chosen reasons could be equally important for an effective adjudication in a democratic functioning of judiciary, which would have a potential to develop the law in future. So I respectfully disagree with the opinions expressed by my esteemed brothers. At the outset, I have not approved the manner in which the three-judge bench had referred the matter to the larger bench without assigning any reason. So I have said that it may be noted that Andhra Pradesh Scheduled Caste Rationalization of Reservation Act 2000 has already been declared unconstitutional by the five-judge bench in E.V. Chennaiya as well as in 2005. Similarly, Section 4.5 of the Punjab Scheduled Caste and Backward Classes Act 2006 has also been declared unconstitutional by the Division Bench of the High Court of Punjab and Haryana, while the judgment dated 29th March 2010, in respect of which present reference is made. Hence, both these acts, as on the date, have been declared unconstitutional. It is further required to be noted that E.V. Chennaiya decided in 2005 was holding the field for about 15 years till five-judge bench in Devinder Singh on the reference made by the three-judge bench further referred the matter to the seven-judge bench in 2020. It is noteworthy that three-judge bench had referred the matters to the larger bench without assigning any reason, much less cogent reason as to why it could not agree with the decision in E.V. Chennaiya delivered by the Constitution bench. The law was settled by the Constitution bench and was prevalent since 15 years was sought to be doubted and unsettled by the three-judge bench by passing a very cryptic and perfunctory order not supported by any reason as quoted herein above. The importance of doctrine of binding precedent in the administration of our judicial system hardly needs to be reiterated. The doctrines of precedents and practices are the core values of our legal system. In series of cases, the constitutional benches of this court have time and again emphasized that when a decision is rendered by this court, it acquires a reliance interest and society organizes itself based on such legal order. When substantial judicial time and resources are spent on the references by the constitution benches, the same should not be further referred to the larger bench by a smaller bench in a casual and cavalier manner and without recording reasons for disagreement. In the instant case, the reference was made by the three-judge bench to the larger bench for revisitation of the earlier decision of Constitution bench in E.V. Chennaiya without assigning any reason and in a very casual and cavalier manner, and that too after 15 years of its attaining finality. When a law was settled by the previous bench in E.V. Chennaiya, after considering the previous judgments, including Indra Swani, and after investing substantial judicial time and resources, and when the same had held the field for substantially long period of 15 years, in my opinion, the very reference by the three-judge bench to the larger bench for reconsideration of the decision in E.V. Chennaiya, that too without assigning any reason, was inappropriate and not in consonance with the well-settled doctrines of precedent and stare decisions. Having said that, I have dealt with the constitutional interpretation. It is quite well settled that in interpreting any law, including the Constitution, the text of the provision under Constitution under consideration would be the primary source for discerning the meanings that inhere in the enactment. Sometimes, as a matter of constitutional necessity, it may be prudent to widen the search for the true meaning, purport, and ambit of the provision under consideration. However, one has to bear in mind that no provision, no word, or expression in the Constitution exists in isolation. They are necessarily related to transforming and in turn being transformed by the other provisions, words, and phrases in the Constitution. Even if a dynamic interpretation is necessary and necessary and the meaning necessary to fit in the same circumstance is found in the text itself, it would be always better to tread a path as close as possible to the text by gathering the plain ordinary meaning to see whether that meaning is validated by the constitutional values and the scheme. While giving a broad and generous construction to the constitutional provisions, the rule of plain meaning or literal interpretation, which remains the primary rule, has to be kept in mind. As transferring from the, I quoted the Constituent Assembly debates. As transferring from the Constituent Assembly debates quoted here in above, the object of inserting Article 341 was to eliminate the necessity of burdening the Constitution with long list of scheduled castes and scheduled tribes. It was proposed that the President, in consultation with the Governor or ruler of the state, should have the power to issue general notification in the Gazette specifying all castes and tribes or groups thereof deemed to be scheduled castes and scheduled tribes for the purpose of the privileges which have been defined for them in the Constitution. The only limitation put was that once a notification has been issued by the President, any elimination from or any addition in the list must be made by the Parliament and not by the President. In the words of Dr. Ambedkar, I quote, "The object is to eliminate any kind of political factors having a play in the matter of disturbance in the schedule so published by the President." On the legal provision of Article 341, I have said, from the aforestated legal position, there is no room of doubt that the presidential list, as notified under Article 341, assumes finality on the publication of the notification, and that the caste, races, or tribes, or part of or groups within caste, races, or tribes specified in the notification are for the purposes of Constitution deemed to be the scheduled caste in relation to that state or union territory as the case may be. It is only the Parliament by law which can include in or exclude from the list of scheduled castes specified in the notification notified in clause 1 any caste, race, or tribe or part thereof, or group within any caste, race, or tribe. Such notification notified under clause 1 cannot be varied even by the President by issuing any subsequent notification. Scheduled castes are not a caste within the ordinary meaning of caste. It is by virtue of notification of a President under Article 341 that the scheduled castes come into being. Though the members of the scheduled castes are drawn from different castes, races, and tribes, they attain a new special status by virtue of the presidential notification. A bad reading of Article 341 brings out the quintessential concept that scheduled caste is an amalgam of castes, races, groups, tribes, communities, or part thereof, and is a homogeneous group, and that once notified by the presidential list, they acquire special status of scheduled caste, which cannot be varied except by the Parliament by law. On the state's competence to enact the law, I have said that though the executive power of the state government is coextensive legislative power of the state legislature, none of the entries either in list 2 or list 3 of the 7th schedule confers any legislative power upon the state to rationalize the reservation by subclassifying or subdividing the caste enumerated in presidential list prepared under Article 341, as was sought to be done by the state of Andhra Pradesh, nor does it confer any power to provide or reserve the quota for a particular caste or caste from amongst the scheduled castes enumerated in the presidential list prepared under Article 341 of the Constitution, as was sought to be done by the state of Punjab and Haryana. In absence of any executive or legislative powers, The states are not competent to divide, subdivide, subclassify, regroup the castes, races, or tribes from amongst the scheduled castes, nor could it give any preferential treatment by reserving a quota for a particular caste, race, tribe out of the quota reserved for the entire scheduled caste. So subclassification or subdivision of caste amongst the scheduled caste by the state for the purpose of reservation per se may not amount to inclusion or exclusion of any caste from the presidential list of scheduled castes. It would certainly amount to tinkering with or varying the notification notified under clause 1, which is clearly prohibited under clause 2. When all castes, races, or tribes enumerated in the presidential list are deemed to be the scheduled caste for the purposes of constitution, any preference given to or any quota reserved for a particular caste or race or tribe out of the quota reserved for the entire class of the scheduled caste for the government jobs by the state would certainly deprive the other members of the scheduled caste from having the benefit of reservation to the extent the quota is reserved for such particular caste or caste. Any such action on the part of the state would not only tantamount to discrimination in reverse and violation of Article 14, but would also tantamount to tinkering with the Article 341 of the Constitution. Article 15.4 is an enabling provision which enables the state to make special provision for the advancement of any socially or educationally backward classes of citizens or for the scheduled caste and scheduled tribes, and clause 5 thereof enables the state to make special provision for them in respect of admission to educational institutions. Similarly, Article 16.4 enables the state to make any provision for reservation of appointments or posts of any backward class of citizen, which in the opinion of the state is not adequately represented in the services under the state. These provisions under Article 15 and 16 are merely enabling provisions and could not be treated as a source of power to legislate the law for subdividing or reclassifying or subclassifying or regrouping the caste, races, or tribes enumerated as scheduled caste, which have acquired special status by virtue of Article 341 of the Constitution. On the affirmative action, I said, under the guise of providing reservation or under the pretext of taking affirmation action for the weaker of the weakest section of the society, the state cannot vary presidential list and tinker with Article 341. Such power, if exercised by the state in absence of any executive or legislative power, would be colorable exercise of powers. It hardly needs to be reiterated that the idea conveyed by the doctrine of colorable exercise is that although apparently a legislature in passing a statute purports to act within the limits of its powers, yet in substance and in reality, it transgresses its powers, and transgression being veiled by what appears on proper examination to be merely a pretense or disguise. As well settled, the whole doctrine of colorable exercise is based on the maxim, you cannot do indirectly what you cannot do directly. Any action of the state in the name of affirmative action, if not permitted by the Constitution, could not be validated or vindicated by the courts by molding or tinkering with the specific provisions of the Constitution. In view of the above, I am of the opinion, I've discussed Indra Sahani and Nagaraj and Janil Singh, and then I've said, I am of the opinion that Indra Sahani had sought to define backward class in terms of social backwardness while considering the ambit of backward class for the purpose of Article 16.4. It did not deal with the issue for the scheduled caste or scheduled tribes, particularly in the light of Article 341 or 342. Rather, it categorically kept the scheduled caste and scheduled tribes outside the purview of consideration. The scheduled caste being the most backward class amongst the backward classes and having acquired special status by virtue of Article 341, the question of defining backward class scheduled caste did not arise and rightly not dealt with in Indra Sahani for the purposes of Article 16.4 of the Constitution. The affirmative action of the states have to be within the constitutional framework, and if they are not, the courts cannot ratify the same by bending or molding the specific mandates contained in the Constitution. Article 142, even with the width of its amplitude, cannot be used to build a new edifice where none existed earlier by ignoring constitutional provision, dealing with the subject, and thereby achieve something indirectly which cannot be achieved directly. The action of the state, though well-intentioned and affirmative in nature, if violates the specific provisions of the Constitution, cannot be validated by the Supreme Court in exercise of its jurisdiction under Article 142. The removal of inequalities or remedy to remove inequalities cannot be permitted at the cost of violation of the specific provision of the Constitution. When the wordings of the provision of the statute, in the instant case, Article 341 of the Constitution, are clear, as also the intention of the draftsman of the Constitution, the court cannot add or subtract the words from such provision to give it a meaning which the court feels would achieve the goal of social transformation. Sometimes the affirmative action and the Constitution intersect with each other in complex ways, as affirmative action policies are framed by the states to promote diversity and to address historical inequalities, while the legal frameworks have to ensure that these policies are implemented within the bounds of the Constitution. The implementation of the affirmative action policies must align with the constitutional and legal principles, particularly those related to equality and non-discrimination. In short, the affirmative action and the legal frameworks, though both aim at more equitable society, they must navigate complex legal principles to ensure fairness and constitutionality. I am therefore of the opinion that the law laid down by the five-judge bench in Ivicinea is correct and deserves to be confirmed.
I have divided my opinion into 7 parts, starting with introduction, amendment to the constitutions vis-a-vis the reservation with reference to the case laws, central government and state government's commission on scheduled caste, scheduled tribes and OBCs, ramifications of reservation, casteless society, caste system vis-a-vis the bond system. Reservation is only a medium of facility and its execution revives caste. And then the conclusion, which I agreeing with the scholarly separate opinions authored by the Chief Justice and Brother Justice Gavai, I summarize my views as under. The policy of reservation as enshrined under the Constitution and by its various amendments require a fresh relook and evolvement of other methods for helping and uplifting the depressed class or the downtrodden or the persons belonging to scheduled caste, scheduled tribe, and other backward classes communities. So long as no new method is evolved or adopted, the system of reservation as prevailing may continue to occupy the field with power to permit sub-classification of a class, particularly scheduled caste. In the constitutional regime, there is no caste system and the country has moved into a casteless society. Except for the deeming provision under the Constitution for the limited purpose of affording reservation to the depressed class of persons downtrodden or belonging to SC, ST, and therefore, any facility or privilege for the promotion of the above category of persons has to be on a totally different criteria other than the caste, maybe on economic or financial factors, status of living, vocation, and the facilities available to each one of them based upon their place of living, urban or rural. The reservation, if any, has to be limited only for the first generation or one generation. And if any generation in the family has taken advantage of the reservation and have achieved higher status, the benefit of reservation would not logically be available to the second generation. It is reiterated that periodical exercise has to be undertaken to exclude class of persons who, after taking advantage of reservation, has come to march shoulder to shoulder with the general category. The reference is accordingly answered and it is held that sub-classification of scheduled caste is permissible in law for the purposes of reservation. Thank you.
Justice Sharon.
Privilege of reading the lucid and Dr. Justice D.Y. Chanchu, Chief Justice of India, and Honorable Mr. Justice B.R. Gavai, respectively. I am fully in agreement with both opinions to the extent that the validity of sub-classification within scheduled caste has been held to be constitutionally permissible. Moreover, I am fully in agreement with the opinions to the extent that any exercise involving sub-classification by the state must be supported by empirical data that ought to underscore the more disadvantaged status of the subgroup to which such preferential treatment is sought to be provided vis-a-vis the constitutional class as a whole. However, on the question of applicability of creamy layer principle to the scheduled castes and scheduled tribes, I find myself in agreement with the view expressed by Justice Gavai, that is, for full realization of the substantive equality inter se, the scheduled caste and scheduled tribes, the identification of the creamy layer qua scheduled caste and scheduled tribes ought to become a constitutional imperative for the state.
Grateful to know.